All right, everyone, I'm going to call the docket exactly at 9. So it should be 9 in about a minute. How was it? That's what Vashawn said. Vashawn, you know how you and Deputy Laura teased me about going to the solar event and they didn't hand out light bulbs? Well, I was at an event and it's for National Night Out.
They gave like
Guess what they did?
light bulbs.
Yes, I have my light bulbs. Yes, and you know what? The light bulbs are Eco Smart and they're purple for National Night Out.
I only have 18.
And it's also for domestic violence awareness. So of course I brought you guys extra. All right, everyone. I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Gustavo Jimenez, custody. Christian Allen Ruiz Garcia. Thank you. Patrick Michael Cuellar. Christopher Alexander Gutierrez, custody. Ruben Renteria. Adrian Alexander Holmes, custody. Jesse Lutzenberger.
Present.
Thank you. Chris Cervantes. John Castro Lopez, custody. Anthony Jacob Herrera. Raymond Francis Hayes II. Jesse Noel Ramos. Brandon James McCaskill. Christy Riojas. Joe Anthony Thomas. Naomi Alba. Eric Mason. Custody. Maria Magdalena Cisneros. Julian Tovar, custody. Javier Balderas. Genevieve Perez. Jacob Rodriguez. Custody. Donna Ellis, custody. Jenna Rodriguez, custody. Willie Castilla Contreras.
Yes, Madam President.
Thank you. Kimberly Nieto, custody. Reginald Green, custody. Joshua Jacob Cannon. Thank you. Darwin Otomar Gomez Jr.
Your Honor.
Thank you. Brandon James McCaskill. Esteban Tiarina. Jesus Velasquez, custody. Ikeli Brooks Jr. Ikeli Brooks Jr. All right, thank you. All right, is there anyone who's present and your name was not called? All right, attorneys who are here, some of you are new, so these are the rules. Please follow these rules and court will run smoothly. Criminal trial division is there, family violence is there. If you have one of those cases, just speak with the attorney. You're not ready to approach the court unless you confer with the state and confer with your client. If your client is in custody, they will need to be brought out. Just request that person from the deputy. Once they've been requested from the deputy, do not leave the courtroom because for security reasons, only a few inmates are allowed at one time. If your client wishes to speak to the court in a language other than English, you will need to have an interpreter here, whether you speak the language or not. When we are on the record, do not talk behind the court reporter. Just raise your hand and the deputy will move you and your client to the other end. How do you know we're on the record? Because I will have called the style of the case. To the back here is Miss Abrams. She's our probation liaison officer. And also, should I say a Jane of all trades? Or should I say a master of all trades? If your client is seeking probation, if your client is on probation, confer with her because I'm going to ask for her opinion. All right, everyone, today is Monday. We're still not retired, but guess what? We can look forward to retirement still. So everyone, please confer, have some patience in your pocket. I'm going to take 5 minutes to speak to a couple of people on a case, and we will be back. Mr. Arguelles. Arguelles, yes. Are you on the Just give me one moment. Let me log into Odyssey. Okay, Odyssey says it is checking for updates. Like there are no update, Odyssey. Who's the first one you have?
First one is going to be on page 9, second one. This is Enrique Alexander Velasquez, the most involved with interpreters.
Thank you.
Ready?
Jesus Enrique Alexander Velasquez. All right, we're going to go on the record. The court is calling 2025 CR 0077972. State versus Jesus Enrique Alexander Velasquez. Could I have the parties announced?
Rick Benny for the state of Texas.
Thomas Taylor, ready?
And are you Mr. Velasquez?
See.
Yes.
All right, we're here for our motion to set bond. And it appears that the state has agreed on a bond of $10,000. Is that correct?
Yes, sure.
All right, and what is Mr. Velasquez's criminal history? I'm assuming since he's charged with continuous violence against family, there's a previous assault case.
Desde este lado. Vuelve hacia este lado.
Excuse me, you all can't do the side chatter because the court reporter is taking down everything that everyone is saying. And I'm sorry, could I have the interpreter, if you could raise your right hand for me, please? You solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. If you'll state your name for the record.
My name is Catalina Delgado, Delgado, license number 2222.
All right, and state.
So he had a previous assault yet in April 11th, 2024, that became part of this current continuous violence case against the family. Otherwise, he doesn't have,
And the previous assault, is that the same complainant?
it's a sense of this time.
All right, Mr. Velasquez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
It's huge.
Yes.
All right, so here's the thing. Either you're going to speak in Spanish or you're not.
Habla español.
Hablo español. Yes, sí, ma'am.
I'll
Sí.
speak Spanish, yes, now.
All right. And the reason why I say that is because we have an interpreter here. All right. Have you ever had any type of mental health diagnosis?
I'm sorry, what did you say?
Have you ever had any type of mental health diagnosis?
No, ma'am.
Have you
No,
ever
ma'am.
been, thank you. Have you ever, yeah. I guess we're gonna speak in English and in Spanish. Have you ever received any type of medication for any type of mental health treatment?
No, pues,
No, Judge.
Have, in the past, have you ever used any type of drugs?
no, pues.
No, Judge.
All right, this is what the court is gonna do. What is his current bond set at? Counsel, what is his current?
The clerk says there's no bond at this time now.
There's no bond that's been set?
It was originally 10,000. He could use the court date and he was remanded without bond.
All right, so we have someone who's missed a court date. Counsel, why did he miss his court date?
Respectfully, at the time, his new wife was in the hospital and he had to pawn his phone at the time because he had no money and he had to come up with 40,000 pesos. And it was on the Mexican side. They all live in Laredo. But now he will have a phone. Now he will have a place to stay. Now they lost. They had a very tragic incident with the new wife. And at this point, Your Honor, he's no longer with the victim in this case. At this point, Your Honor.
Well, here's my question. The wife that he was helping in Mexico, is that the same wife who's the complainant?
No, Your Honor, it's different. It's a new one.
So this new alleged person, is that his girlfriend? Why he has, so he has a girl,
She's on Zoom as well.
so he has a girlfriend in San Antonio.
No.
It's in Laredo.
No.
Well, this wife that you're saying that he had to get money for,
No, this is a new wife.
and is this new wife somebody other than the complainant in this motion?
Yes, Your Honor.
So he has somebody in the complainant in the motion. Is this complainant in the motion his girlfriend?
No longer together, Your Honor. No longer together.
And you say there's someone on Zoom who wants,
Yes, she's going to be the new wife that he had to sell his phone to be able to pay for a medical emergency. And I can call as a witness if she should be on Zoom, Your Honor.
oh, she is. Could you unmute, please? And show video. All right, so the fact that while she's waiting to unmute, so the fact that he had to sell his phone, that still doesn't explain why he was not in court.
He didn't have a way to get notification about the court date. He did not know. But now he understands how important it is to make his court appearances in the future.
So how long has he been in custody?
2 meses y
2
una
months,
semana.
2 months and
2 months and 2 weeks.
So the warrant for his arrest was issued in July.
He may have some time from before, Your Honor.
No. I mean, I'm saying he was issued in July. So is he saying he's been in custody since July?
No, es porque en junio fue cuando empeñé el celular.
No, because in June, that's when I pawned my cell phone.
O sea, no tenía forma de saber cuándo tenía la corte.
I had no way of knowing when my hearing was going to be.
Y no tenía trabajo tampoco.
And I also didn't have a job
Porque me despidieron por haberme movido a México por la emergencia médica que tuvo mi esposo.
because I was fired since I had to move to Mexico for the medical emergency my wife had.
No, when you have a charge, you're given a court date before you're released. Wasn't he arrested for this offense? If he was arrested for this offense and it was not at large, he would have had a court date when he was released from the jail. That's my question, counsel.
¿Cuál es la pregunta? No, cuando yo salí la primera vez, estuve preguntando.
When he first got out, he was asking.
But no.
Okay.
So here's the thing. If he's talking, I need the interpreter to interpret.
Cuando salí la primera vez, los primeros meses estuve preguntando diariamente sobre la corte y ellos me dijeron que dejara de hablar porque ellos me iban a avisar.
When I first got out, I kept asking. I asked for about a month and they told me to stop calling, that they would let me know.
He was calling daily also.
He's calling daily.
So
I mean, well, that's what he's saying. Where's the proof that he pawned his phone and he paid a medical bill? Do you have that?
Yes, Your Honor.
Yes,
I just got email from the wife.
you need to show it to
the
the state.
And this is for you. I just sell his phone.
Yes, I do see.
To get phone. I broke my phone to people. That's fine. I apologize, I just got email. So I talked to. And but let me just show you how that works. This is for the phone. If you close it, you see the hospital bill. In the same email. On the right hand side, it's all in Spanish, but we can use interpreter to maybe explain the hospital bill. Okay. He can read the document and explain to the court.
I
How
don't
much,
need an explanation.
thank you.
I cannot fluently speak Spanish. However, I can read Spanish.
Thank you.
It's actually similar to French. Actually, your account.
Thank you.
All right, this is what the court is going to do. The court is going to set your bond at $30,000. Who's the complainant?
Name is Azamet Daughters. That is spelled Azunhenhet.
H-E-T?
Yes, Your Honor. And then Torres is common spelling, Torres.
All right, the court is going to set your bond at $30,000. There should be no contact with Azamet Torres. And there's to be GPS partial for employment until further notice. And I'll ask that GPS fees be waived. And Norma, give him a set date. Your jury trial date is set for November 4th. Thank you.
You know.
You're welcome. Donata? Yes. Okay, all right. Thank you.
Your Honor, may I get a signature?
Yes,
Thank you.
there you are.
Your Honor.
But he can stay in Laredo, Your Honor. He can live in Laredo.
I'm sorry, what?
He can live in Laredo.
I'm not in charge of his residence. All I'm telling you is that he's on GPS. His bond is set at $30,000 and he's not to have any contact with that complainant. If he does, a warrant's going to be issued for his arrest.
Thank you.
Thank you.
Maybe you shall.
Yes, once he gets his reset paper. Hi.
You mind passing your,
Yes, okay.
What, this one?
is that the one for? Yeah.
I don't know which one it's it for. Thank you. Okay. Who else is ready?
Okay, we have page one, first one, so the minutes.
All right, Gustavo Jimenez. Thank you. Hello, Mr. Jimenez.
Good morning.
Good morning. How are you doing today?
Good, how are you?
Oh, I cannot complain. It's a beautiful day outside. Not too hot, not too cold.
I like that.
All right. All right. So where are we on this sanity evaluation?
It's still pending, Judge. Mag Court went ahead and set it for January 8th. It's my understanding, they're having a little bit of an issue with the availability of the evaluators, Judge. So we're still just waiting on that. In terms of discovery, we did give acknowledgement of discovery to the clerk here, the court, for processing, Judge. So there are 45 videos. We believe that discovery is intact at this point. So there's that issue, Judge. I also did file a motion to set bond. He's currently remanded without, Your Honor.
Okay.
I wanted to see if the court would have availability this Thursday to hear that. I need to get some criminal history information from him, as well as call potential witnesses. And I did just file that last week through e-filing.
All right, Norma. Set this for Thursday for them to have their bond hearing. And then state in defense, if you confer on a jury trial date, it'll be your jury trial date and plea deadline date, because I know you're waiting for the sanity evaluation. So if you all could pick a date, perhaps in February.
Yes, Your Honor, will do. And upon getting that date, Your Honor, can I communicate that to the coordinator?
Yes. Oh, I think she's getting it now.
Oh, sure.
I think it's February 3rd. All right, February 3rd will be your jury trial date and plea deadline date. If your attorney wants you brought sooner, he will let the court know. And you'll also be back on Thursday for a hearing on your bond motion.
Thank you, Your Honor.
You're welcome.
Judge.
You too. Counsel, is there anything else?
Nothing further, Your Honor, may be excused.
Yes.
Thank you.
All right, who's next?
Next is page two. Six one down. Anthony Herrera.
No problem. All right, Anthony Herrera, where are you? Hello. Good morning. So the state has filed a dismissal. They're saying they are dismissing it for further investigation. So that means that maybe your case may come back, maybe it will not come back. Your attorney will let you know about that. But here's the thing, whatever is going on in your life, I don't know. I don't know whether there's sufficient evidence to prove this or not, but you're going to have to make some changes so that you don't appear back here, either by mistake or because somebody's filed a wrong charge or because of something that you've done. This is your chance to change your life. How old are you?
18.
All right, you're 18. You can tell you don't want to be here, right? And you see the inmates over there? You don't want to be there and you don't want to be at the Bexar County Jail. So what do you have planned for your future?
Become a tattoo artist. That's what I've been doing.
What have you been up to?
I've been working just tattooing.
All right, so what type of work have you been
I've
doing?
been doing a labor job at a stadium where I just unload trucks,
Okay,
and then it's a 40-hour week job.
yeah. So what's your dream job?
Tattoo artist.
I'm sorry?
The tattoo artist.
I'm sorry, I can't hear for some.
Tattoo artist.
Oh, tattoo artist. Did you do your own tattoos?
Did some when I was like 14.
All
Long
right.
time ago.
I always watch this show. What is it called? Ink Masters or something? And then sometimes, their canvas is not doing well. And so they're like, I'm gonna tattoo myself. So I always wonder. So you said that's your dream. That's what you're gonna do. So what have you been doing to make that dream happen?
Just been sticking to working and tattooing. That's all I've been doing.
But have you been improving your craft? Sometimes when I watch Ink Masters, you'll have tattoo artists on there. They actually go to art school because they say going to art school really helped them. So you're going to have to step up your game because everybody is becoming a tattoo artist. So you need to figure out what genre you want to work in. Be a master at a genre, but be able to do everything. Because some people, they say they can only do black and white. They can't do color. And you watch Ink Masters, they always give them a challenge and say, we want you to do color, or we want you to do new school.
Yeah.
We've never done new school. So you need to be able to do it all, okay? All right, good luck to you.
Thank you very much.
You're welcome. All right, thank you. Thank you, guys. I'm sure we'll call you back. All right, who's next?
Nice one.
Page 9, first one.
All right, who is here on Esteban Tiarina?
I think he might have stepped out, Sean.
All right, so once he comes back, we'll take that up. Yeah, don't forget your other person. I know you won't.
Tiarina, we're waiting for your attorney.
You ready to call it?
What?
Alexander.
Also have, page 1. Second one down.
All right, Christian Allen Ruiz Garcia. Okay, who's the person who handed me the riddle? Okay, we're gonna see if somebody can get it. All right, so what's happening with this case? Okay.
Your Honor, these cases are connected to a co-defendant juvenile, where defense had several motions for discovery. We went to the second hearing. Judge Shaw has finally agreed to let us physically inspect both the court's file and the state's file, and then come back with more specificity if I want something duplicated. So that was on Wednesday. We would request at least 2 weeks for me to physically be able to go down there and look at it. We are preparing on a capital murder. State has no objection to letting me go and view those. And that's as far as we've gotten since the last setting, Your Honor. But we did make that progress.
All right, Ms. Ferguson. I need to set for a jury trial date and a plea deadline date, and y'all can get a setting in February.
Understood, Your Honor. May I inquire? We are preparing to file a motion for travel on behalf of Mr. Garcia. He is, they have purchased a cruise ticket for November. Would Your Honor be amenable to us presenting that motion without Mr. Garcia present? Given that he's here today?
That's fine, or if you can talk to the state, see if they have any objections to it, his travel. All right, what date in February? All right, your jury trial date and your plea deadline date is going to be February 17th. If your attorney wants you brought back sooner, they will let the court know.
Thank you.
You're welcome. Thank you. Yes. All right, once you present the motion, I will sign it.
Understood, Your Honor. Thank you very much. May I be excused?
Yes.
Thank you. Why don't we for out there, please? On my way to Floresville.
Ah, drive safely.
Yes, it's all worked out, so I'm happy.
Okay.
I see that. She's got a new one. They just-
Who do we have next?
I swear this one in Judge.
All right. So, Victoria, before you go, this is the riddle that Ross just gave the court. John's mother has 3 children. Their names are Nickel, Dime. What's the name of the third child?
Penny,
No. You know,
3
right?
children,
I'm not sure
75
right
cents.
now, but
Yeah. John's mother had 3 children. Their names were Nickel, Dime. What was the name of the third child? Who said that? Yeah, it's John. Because it's John's mother.
oh.
Oh, you got me, Judge.
No, that's from Ross.
That's a good one. That's a good one. You're right.
Yeah, I've got stuff to ask, so, I mean, I'll stick around. I've got things to work on, so. Brian Cameron, yes, and John Lopez is the defendant.
Sounds on the first page, Judge.
All right, thank you. All right, Rashawn. Guess who has graced us with their presence? Coming in all staff.
Oh, you just have 187.
Jason Garahan has made it back, and he's close to wearing an LSU purple tie.
I actually woke up this morning and I was like, I was gonna be helping out here today, so had to put on the LSD top.
Okay, I feel the love.
Tell mom I said hi.
Okay, I'll let mom know. And then Cornelius is walking around. He's very happy.
Yes, yes.
I said his name and I didn't even have to say it 3 times. Cornelius, congratulations.
Set up for the blood discovery on the eye. That's what I'm talking about. You're next. That's right, that's right. You're next. Be at the game.
Oh, he's gonna be at the game. Cornelius, are we gonna have prayers and tears at the next game?
The only thing that really hurt me
Mhm.
is that they made my boy the underdog at home.
You're gonna have him as an underdog at home.
How did you make us the underdog at home? Haven't learned yet.
Well, people say they upset with Belichick. And we're gonna see what happens with us with South Carolina.
We get South Carolina.
Well, I'm holding on to what you say. All you have to do is just go win.
Keep winning.
Keep winning.
Yeah.
So you guys have started
Yeah. They made us the underdog boy.
at home.
At home. And it's fun.
That is wrong. Well, congratulations.
Well, I appreciate it. I feel it. I had to come here.
All right, who is here on Christopher Gutierrez? All right, and council, is there going to be any applications?
You need a scan?
Oh, yes. Hello, Mr. Gutierrez. All right, the court is calling 2024 CR 0128855 State versus Christopher Gutierrez. Could I have parties announced?
Rolando Arguez for Mr. Gutierrez.
And are you Mr. Gutierrez? All right, Mr. Gutierrez, Mr. Arguez was appointed to represent you. Your previous counsel had a medical issue and asked that they be removed from your case. Your attorney is entitled to 10 days to prepare for trial. Of course, he was just appointed. Do you still wish to continue, or do you wish for him to have 10 days?
All right, get it on done.
I'm sorry?
Get it on done with.
All right, and Mr. Arguez, are you waiving your notice?
Yes, Your Honor.
And have you had sufficient time to speak with your client and review the case?
Yes, Your Honor.
All right, and counsel, have you received all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gutierrez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you waiving the reading of the indictment? Counsel, are you
Yes,
waiving
Your
the
Honor.
reading? State, are you proceeding on the indictment as presented? Any objection?
No objections, Your Honor.
Mr. Gutierrez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. The punishment range is as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry? No. I'm going to go through it slowly with you. And if there's something, here's the thing. Take a deep breath. All right, so I'm going to go over this slowly with you. If there's something you don't understand, let me know, all right? And counsel, I know that you've explained this.
Yes, Your Honor.
Sometimes questions are complicated, so I'm just going to break it down. Do you understand you have a right to have a jury? That would be 12 people who would sit, and they would get a chance to hear whatever evidence the state would bring, and that evidence would be brought in the form of witnesses. Do you understand?
ma'am.
And your attorney would have a chance to cross-examine those witnesses. Do you understand?
Mhm.
And do you understand the state would not be able to call you as a witness if this were a jury trial? Do you understand?
Yes, ma'am.
All right, because you're entering into this plea bargain agreement, the state is not going to call any witnesses. Your attorney is not going to get a chance to question any witnesses. Do you understand? And do you understand also that if anyone wants you to testify, you've given up the right to say, I'm not going to testify. Do you understand?
Yes, ma'am.
All right. Is there anything you do not understand?
Mhm.
All right. Oh, thank you. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gutierrez, has anyone promised you anything than what the agreement is?
Oh, ma'am.
Has anyone threatened you, coerced you, or placed you in fear to enter into this agreement?
Good, but I'm looking at it.
All right. Are you satisfied with the way you've been represented?
Ma'am.
Did you understand by entering this plea, if you're not a US citizen, you will be deported? Do you understand?
Ma'am.
If you're not a US citizen, you won't be allowed to legally re-enter the United States. Do you understand?
Right.
If you're not a US citizen, you are going to be denied naturalization. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. This is your plea bargain agreement. Did you review it with your attorney? Did you understand it? So what you've agreed to is to serve 1 year in the state jail facility. There's a $1,000 fine. What I can tell you is legally, whatever time that you've been in custody, I have to give you credit for that time. Do you understand? But for the court, your agreement is 1 year in the state jail facility and a $1,000 fine. You're not applying for probation or deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? This paragraph, that's the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? When you sign that, that means that you're waiving your right to appeal. So you can't come back and complain about this plea unless your attorney has filed some motions. I've heard those motions and made a ruling on them. Do you understand? Counsel, are there any such motions?
No, Your Honor.
So to the offense that you're charged with and this indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections, Your Honor, for purpose of the plea.
All right, and state you may be excused. Did you review this document? It's the waiver and stipulations. All right. Again, you understand you can go to trial if you want to go to trial. You understand? All right. So did you understand and sign this document and all the places you should sign it? Did you understand that the state, again, they're going to present their evidence to prove your guilt by entering into the record police reports and any prior judgments that you have to prove jurisdiction? Do you understand? Court will find that defendant has knowingly and voluntarily waived and stipulated to testimony of stipulations. Court will accept into evidence state exhibits 1 and attachments, and the court is reviewing the same. All right, counsel, is your client stipulating that the person who's listed as S1 is also D1, and that is your client?
Correct, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
That the court follow the agreement.
All right, the court will follow your agreement. The court is going to sentence you to 1 year in the state jail facility. There's $1,000 fine. Time and money run concurrently. I'm going to give you credit for any time served. I'm going to suggest the therapeutic community or recommend that. It will still be up to you whether or not you want to be in that program. It doesn't increase the time you're in custody. It's just to help you with any type of issues you may have, be it mental health issues or drug issues. Do you understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Gutierrez, you're going to have to change because you're going to get to a point where these state jail felonies, the range of punishment is going to end up being 2 to 20. You understand? All right, good luck to you.
Thank you, Your Honor.
Thank you. You too. Thank you, counsel. All right, Esteban Tiarina. All right, your attorney's not here. Oh, Esteban Tiarina.
Yeah. Morning, Your Honor.
Good morning. All right, so before we go on the record, this is just a motion where council is asking to change his hours for work. My understanding from reading the motion, there have been no violations and states you were previously agreed that he'd be allowed to work.
Yes, sir. It's just taking it from, he was working Mondays, Wednesdays, and Fridays. We're simply asking that he can work Monday, Tuesday, Wednesday,
All right.
Thursday, and Friday, Judge.
All right, if you'll give that to the clerk, or either take it to the clerk in the back, they'll make a copy for you.
Yes, Judge.
All right, thank you so much.
Thank you, ma'am.
All right, you too. All right, anyone else ready?
Page 2 and 4 down.
Chris Cervantes,
Yes, we were here on August 21st.
all right. So, hello.
Hey, how are you?
All right, how are you doing this morning? Thank you for dressing appropriately for court. So we are here to see if the blood discovery has been completed.
It has not.
All right, what's the holdup on the blood discovery? It's been since July.
I don't know, I do know DPS since 90 days, and then further looking at this, I've not seen the signed discovery order was sent, so I would just respectfully ask for one more recess so we can ensure that a rush request is sent and we get that. Wow.
All right, Norma, we're gonna set this for a jury trial date and a plea deadline date, and counsel, if you want to bring him in sooner, you can.
Yes,
And please bring him in sooner before the jury
yes,
trial
I
date
will
if
definitely do
the
that.
blood discovery is not completed.
Yes,
All right, Norma, can you do this sometime in February? February 17th?
for that, but I will bring him in much sooner than that.
All right, so we're gonna set you for a jury trial date and a plea deadline date, February 17th. However, your attorney will probably have you brought back sooner.
Thank you,
All right,
Judge.
thank you.
Thank you.
Thank you, Judge.
You're welcome. I had to change that. I wrote that down as 2025. Oh, my goodness. All right, who's next?
Page 7, number 2, looking at PR.
All right, who is here on Willie Contreras?
So just need to find out.
Hello,
No, Judge.
good morning. So do you guys finished with your trial?
It was a hung jury,
Oh,
5 jury panels. They deliberated Friday and all day Saturday, and then they declared mistrial.
see, and people were upset because in this court, we had a jury sequestered a while back. It was over the holiday.
It was a 3-day weekend, Judge.
It was a 3-day weekend. But it was great because I was living downtown.
Yeah, it's a difficult case. And it just, that's the first 3 panels completely busted.
Mhm.
4th and 5th were combined to get enough jurors,
Yeah.
and then it was the week of testimony. And yeah,
Oh, wow. Well, of course, we're in trial every week, but we finished our trial and then there was the sewage leak
that
on
was
the first floor. And I was just, people were asking me, is it the north end or the south end? I'm like, I do left and right. I'm like, it's a way, don't go out the way near the cathedral and you'll be fine.
yes. They had a lot of issues with inmates in the 226.
Oh, we had to send, well, Some didn't arrive, but at least we could do it by Zoom, so that was good. All right, the court is calling 2020 CR 2494B, State versus Willie Contreras. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Jay Norton and Patrick Valentine for Mr. Contreras.
And are you Mr. Contreras?
Yes, ma'am.
All right, so we were actually here on September 25th. You entered a plea of true to violation of condition number 5. The state waived all other allegations without objection. Then we called it back for September 29th and counsel was in trial. So now we're here for today.
Yes.
State, what are you requesting? All right, and defense, what are you requesting?
Judge, our initial request would be just a huge change of circumstances. If the court would consider a revocation and then placing Mr. Contreras on 5 years probation, regular probation, understanding that he'll have the felony conviction. But circumstances are such now that he's clean, he's sober, his issues are behind him. He has a lot of family support here behind him. The court wants to hear from some of them. But basically, they will all, I proffer that basically what everybody is going to say is he had his issues there. And quite honestly, he was going to test positive for drugs, and which is why he became a fugitive. It's been weighing on him. He hasn't committed any new offenses, but he's gotten close to in the church. He's now very set in his religious. He's a good family man now at this point. All of his family's here supporting him. Quite honestly, back in the day, they wouldn't necessarily be here, is what they say. But he has proven to them that he is a committed person to family, friends. He's in a long-term relationship. I think it's an unusual set of circumstances. I understand revocation or termination, but Mr. Contreras is asking if the court would allow him an opportunity to be placed on probation. He'd start over 5 years instead of 2 years, and he will be successful, Your Honor.
But has he done anything on probation?
He was not a good candidate for probation back then. I mean, short answer is no. He didn't do what he did not meet his obligations on probation.
I mean, did he ever report?
He did. No.
Okay. All right. And state?
Yeah, right. Obviously, I did not deal with this case previously, but Melissa always had, I believe, recommended 1 year, or that's what we requested state counsel.
Okay. And probation, you recommending revocation?
They are, Your Honor.
Summary judge. Revocation.
All right, so this is what I want to tell you. I appreciate the fact that you've changed your life,
Yes.
but you haven't done anything. So,
Just one thing to add, Judge, I forgot. He's current on all of his fines, and he took a UA, and he is also clean as he stands.
so I'm going to give you a choice today. These are your only choices, right? I am going to grant the motion, revoke. So the state is asking for 1 year state jail. You can either take the 1 year at the state jail facility, and the only reason why I'm giving you this choice is because it appears that you've changed your life, right?
Yes, ma'am.
And sometimes when we change our lives and then we forget, we want everybody to forget about everything else, and that can't be done, right?
Yes, ma'am.
So you can either do a year at the state jail facility or you can do a year at the Bexar County Jail. If there are no objections, I'll do a 1244.
Bexar County Jail.
Is there any objection from the state to the court? All right. And all right, this is what the court is going to do. As previously stated, the court found violation of condition number 5 true. The court is going to grant the motion, find you guilty, revoke. The court will sentence you to 365 days at the Bexar County Jail. Give you credit for any time served. Let me see. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review the document with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. At the Bexar County Jail, I'm not in charge of you receiving a credit of 2 days for every day you spend in jail or 3 days for every day. That's completely up to the sheriff's office. You understand?
Yes.
Now, I could send a message to the sheriff and say, I want you to serve 365 days flat.
Yes, ma'am.
I normally don't do that. I have yet to do that. Now, maybe there may be somebody that should be done for, but I'm not going to do it for you. So that's completely up to them. So please do not call the court or have people call the court and say, I'm not receiving 2 for 1 or 3 for 1, because I'm not in charge of that and I have no control over that.
Yes.
You understand?
Yes, ma'am.
All right. All right, good luck to you.
May we have a moment just to explain what?
Sure, just speak with the deputy.
Thank you, Judge.
You're welcome. All right, anyone else ready?
I have another one, the same page 7, fourth one down, Kimberly Nieto is also an MP.
All right, Kimberly Nieto.
Another. Take a look later.
I like it. All right, the court is calling 2022 CR 7417 State versus Kimberly Nieto. Could I have parties announced?
Rick Pena for the state of Texas.
Ron Ross for responding.
And are you Kimberly Nieto?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kimberly Nieto who was placed on deferred adjudication in 2022 CR 7417 for the offense of aggravated assault with a deadly weapon on September 19th, 2022 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
State Honor violation condition number 41. On or about the 21st day of July 2025 in Bexar County, Texas, the defendant, Kimberly Nieto, did then and there fail to comply with the rules and regulations, the work release GPS program, and that the defendant was removed due to a tampering event in violation of condition number 40.
How do you plead to that? True or not true?
True.
State will waive the other violation.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition 41 true. Is there a proposed agreement?
There is, Judge.
Yes, Your Honor, there is. That is to revoke the defendant's probation, adjudicator guilty and sentenced her to 4 years TC.
Is that correct, counsel?
That is agreement.
All right, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
You're not gonna try to complain about it tomorrow. Appeal.
No, ma'am, I'm not gonna complain.
Are you waiving your right to appeal?
Yes.
All right, the court will grant the motion, find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's an affirmative finding of family violence. There's to be no contact with Gabriel Serda, that's SERDA. And the court will request the therapeutic community to address any mental health issues. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you've reached a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're going to have to make better changes in your life. And when you are released, you are still not allowed to have any contact with that person. Do you understand?
Yes, ma'am.
All right, good luck to you.
One more thing, Judge.
Yes.
You're giving her credit for time served. Would the court consider giving her credit? She went to ISP also, and I don't know if that's part of the automatic
So she was in a lockdown facility?
for 6 months.
State, was that successfully completed?
Yes, Judge.
All right,
She did EDRF 119 days, and she also did ISF, that was 19 days.
all right. Well, legally, I have to give her credit for that, so I will.
Thank you, Judge.
You're welcome.
Yeah, good luck.
Thank you.
All right, who else is ready?
Okay, 1, 4 down. Patrick Wade.
Thank you.
Patrick Michael Cuellar. All right, so is gymnastics season still happening? Is it always year round?
It never stops.
Yeah.
So, yes, it's going. Sadly.
All right, so what's up with the federal case?
Well, so there has been movement, Judge. They have a plea offer. They are going to be entering into a plea arrangement in federal court prior to the 17th of November. That's kind of like their deadline. I did confer with Mr. Garaham, who's not even here. And so I think once that gets entered, I think they're going to be more keen to move on this case.
All right, Ms. Ferguson. I need a jury trial date and a plea deadline date in December, please.
Thank you, John.
Welcome. All right, so we'll be back on December 9th. Thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused. In defense, if you want him brought back sooner, just let us know.
I will let you know, Judge.
Thank you. Anyone else ready?
Yes, sir. On page 5 and 6.
It's awesome, me, Judge.
All right, Jacob Rodriguez.
How did your team do?
Oh, we had a bye. But we play South Carolina next. We'll see how we deal with our loss. I've always been worried about the offense. All right. And are you on all his cases?
I believe I am.
Well, there's Anita Perez.
Just reassigned them today, Judge.
All right. All right, thank you.
Jacob is very new to me, Judge.
All right.
I think I was very recently appointed. However, he has some cases here today and then some that have yet to be indicted. I've conferred with Ms. Galloway.
Mhm.
She's going to get me a global offer in about a 2-week window.
Okay.
And so, whenever the court wants to bring us back in that 2 to 3 week window would be okay.
When do you, 2 to 3 weeks?
Yes, ma'am. I will be out of state at the end of this month, 26th through 30th. So that's my conflict. Maybe the first week November would be better.
All right, Ms. Ferguson. if you can put this at the beginning of November, November 4th.
That would be fine, Judge.
All right, so this is your new attorney and they will make sure that, well, he will make sure that he's in contact with you, all right?
Yes.
So we'll bring you back on November 4th and it's to give him a chance to review the discovery. All right, thank you.
Judge. We'll talk with you, Judge, okay? We'll be in South Carolina.
Hey, you better not be cheering for them.
No. We might be at a golf course in Alabama.
Oh, okay. You have to send photos.
I will. Can we approach?
Yes. Hello. Oh, just give me 1 second. Let me put this in the system. Come on, right, just go to, see.
It's for a job. It's just gonna be wrongful for sure. It's not.
Right, and who is this?
It's on Raymond Haynes, Your Honor.
Hi.
Good morning, Judge. How are you?
Hi. Do you have the cause number?
I do.
Yes.
2025. CR 007473.
All right, so yes.
So last time we were here, Judge, we kind of talked about the quickness that we're gonna try to get an assessment done. We actually called that week. Unfortunately, we were told that it was not a good time to do the assessment. And then we tried calling again, and we have not been able to get a call back. So unfortunately, we don't have anything further besides the fact that we keep trying to call for the assessment. Our BDOs are calling. We can keep trying, Your Honor, but unfortunately, as of today, for the court that you asked, we don't have anything.
Yeah, and so what I remember this case. And so the court recalled the judge's warrant.
Yes, ma'am.
And then we reset it for him to make his appointment. And then we were calling back today. And if he missed his appointment, then the court was going to have to issue a warrant.
Unfortunately, yes, that's my recollection as well.
All right, so let's go on the record. Court is calling 2025 CR 007473 State versus Raymond Francis Haynes II. And a state attorney, please. And for the defense.
Jay Norton from Mr. Hanks.
All right, so the history of this case is as follows. There was a judge's warrant that was issued. The defendant was remanded without bond. The court was made aware by defense in state that the defendant was going to apply for Veterans Treatment Court because he was a veteran. So the court ordered that the defendant appear for his assessment because that seemed to be the issue, that he wasn't showing up for his assessment. So he was scheduled for assessment on October 3rd, 2025. And the court stated that if he did not complete his assessment or make contact for his assessment, then the judge's warrant would be reinstated. So has he made an appearance? I'm sorry, could you state your name for the record?
John Herman, Felony Veterans Treatment Court, and unfortunately, no, Your Honor, he has not completed the assessment.
All right, and what attempts have you made to help him complete the assessment?
We blanked on a date, and I apologize. About a day after we met last time here in court, we called the mom and the defendant, stating the fact that, hey, we can get the assessment done early. At that time, we were told that there was a family member who just had a stroke and that it wasn't a good time because they're visiting. We asked for later that day. We never got a call back. We called, every time our VJOs worked here in the courthouse for felony veterans court, we called. And at that point, nobody was answering. Messages were left, said, please call us back, call us back. Unfortunately, as of a few moments ago, when the reporter called me, we still have not had any confirmation. Mr. Haynes reached back out.
All right.
Family member reached back out.
All right. Any objections to the court reinstating the judge's warrant and remanding the defendant without bond?
No, Your Honor, we understand the situation.
All right. So the court is going to ask that a judge's warrant be issued and the defendant will be remanded without bond. And counsel, if he's taken into custody, would Veterans Court still be open to speaking with him?
Absolutely. Yes, ma'am.
All right. So once he's,
He really needs.
all right. So once he's taken into custody, Attorney Norton, if you will stay in contact with him to let him know so that we can get him interviewed perhaps while he's in custody.
We can do, Your Honor, either in custody or just brought over. We do have a connection that we made in the jail to where I'll reach out to her and just let her know like, hey, if this individual comes through, please call us so we can see what we can do.
All right. All right. Thank you.
Thank you.
You're welcome.
Excuse?
Yes,
Thank you, Judge.
you're welcome. All right. Who else do we have?
Page 4. Second to the fourth at the bottom, Eric Mason.
All right. Eric Wayne Mason.
He's downstairs, Your Honor, nobody had questions.
All right. So why is he being called?
Yes.
Yes. Are you the attorney?
I was doing a study for Chaplain Valenzuela. She's actually indisposed right now.
All right. So what we'll have to do is, Norma, if you can have the MAC come and if you can call, and Deputy Laura, if you can bring up Eric Mason. All right. So just give us a moment.
Thank you, Your Honor.
Thank you. Anyone else ready?
Yes. 7 at the bottom.
Reginald Green. Hi, are you with Mr. Green?
I am, Your Honor. Mr. Green's coming.
Every time I hear Mr. Green, I think of Matthew McConaughey in The Lincoln Lawyer.
Never seen it.
Have you at least read the books? Oh my gosh. Well, there's a scene in it where, you know, the defense attorney is asking for a continuance because they have a missing witness. And the missing witness is Mr. Green. So now you know what I mean, right?
I got it. Every time I hear Mr. and then color, I think of Reservoir Dogs.
Oh, yeah. Oh, yes. All right. Are you all still having your contested?
No, Your Honor, we've reached an agreement, I believe.
All right, the court is calling 2023 CR 10024 State versus Reginald Tyrone Green. Can I have parties announced?
Notice for the state.
Andres Camping for Mr. Green.
And are you Reginald Tyrone Green?
Yes.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Reginald Tyrone Green who was placed on deferred adjudication in 2023 CR 10024 for the offense of unauthorized use of a vehicle on April 16, 2025 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 21st day of May 2025 in Bexar County, Texas, the defendant Reginald Tyrone Green committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
State will waive all others.
Any objection?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 180 days in the state jail facility and take it to consideration cause number 2025 CC 007955.
All right, and that cause number, what is that cause number?
That is the theft piece of green ledger too.
All right, and then as a part of your previous plea bargain agreement, the court was asked to take in consideration county court cause number 70, if everybody could write this down, 709056 and 709057. And what were those cause numbers? The offenses.
I'll be close to the one that we're
Yeah.
taking it 007955 and then 707056.
All right, I'll see if I can look it up. Yes.
So, cause number 709056 is a criminal trespass, and the other is a resisting arrest.
All right. So what has he done on probation other than pick up another theft case? Has he completed anything?
Your Honor, I don't believe he has been out on bond long enough to complete anything. It's my understanding that Mr. Green has been struggling with some mental health issues and is ready to accept any and all help that the state will offer. The underlying offense, I believe, is a unauthorized use of a motor vehicle that stems from a confusion with his parents. His father is here, present, and is standing behind and supporting Mr. Green. I am not. I do not believe that Mr. Green has successfully completed any of the other conditions of his supervision, but the desire is to pay his debt to society and then to relocate up to Texarkana with his family, and then be with his support network up there so they could help assist him in getting on track with everything.
All right, what I can tell you both is I don't think 180 days is appropriate. He was on probation for unauthorized use of a vehicle.
Yes, sir.
Which is sort of close to being a theft. Sometimes the state will file it as a theft of a vehicle. Sometimes they will file it as just unauthorized use. And then while he's on probation, he's released and he immediately picks up with another theft case. That's in May.
Yes, Your Honor. The theft cases, I believe, are shoplifting, not a forceful dispossession. And from what I understand, there may have been some other factors at work, but from our perspective, the decision to request that the state offer Mr. Green the ability to serve some time on their revocation was something that was agreed upon by all parties to help facilitate Mr. Green's getting past all of these incidents. I do believe he has a number of days in custody as credit that we would ask the court to attribute to him. But
he has an unauthorized use that he's on probation for April 16, 2025. He doesn't do anything on probation. The only thing he does is pick up another theft case on May 21st, 2025. I'm assuming he gets arrested at some point in time for that, gets released, and then in June, he's alleged to have committed another theft of 2025. I just don't think 180 days is appropriate for him because he hasn't done anything on probation other than pick up new offenses. Y'all are dimming the lights. All right, so this is what the court is going to do. The court is finding you guilty, finding, as previously stated, found violation of condition number 1 true. The court is revoking. The court is taking in consideration 2025 CC 007955. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, and the court will request the therapeutic community.
Your Honor, if the court would entertain a little bit of testimony as to the underlying, if that might
Sure.
have the court can reconsider in its assessment. We would like to call Reginald Green, Senior. to
Mr. Green?
testify.
Here, you're back against.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Reginald Green.
All right, yes.
Mr. Green, who are you in relation to Reginald Tyrone Green?
That's my son.
Okay, and are you familiar with the underlying charges of the unauthorized use of a motor vehicle?
Yes, that was our vehicle that we gave to him. He was going through a breakdown at the time. He brought the car to get the what's called miles to get some work done on it. Came up to be $1,000-some. With his breakdown, he just figured he could go get the car, take the car. The people saw his state. They didn't press charges. We paid the $1,000, but my wife decided to take the car back because of his mental state.
Okay, so let me stop you right there. So here's the thing. Once somebody has been placed on probation, they're placed on probation. It would probably be best for you if you are now saying that he is innocent of these charges, didn't commit these charges. That's something for the public integrity unit of the district attorney's office. But I cannot legally go back and undo the fact that he's on probation.
He mentioned it.
Yeah.
I understood.
So here's my thing. Why, if you know, why is your son, he's on probation for a theft case, and he, the unauthorized use, and he continues to pick up more theft cases?
Because he was going through a mental situation. We committed him into the hospital because.
And when was he committed into the hospital?
I can't recall right now, but it is record that he was there. But the thing is with Reginald is with his kids. His kids are more important to him. His wife used his kids to keep him from seeing it. Because he's not stable, he gets upset. So that's why she puts him on where he can't come. Then, so he don't know how to handle that. So he do things like he really don't have a place to live. So when he was stealing, he was just trying to get it wrong. I've been trying to get it to Texas County because I know I can help him. But leave his kids. No one wants to see them. If you knew Reginald, you would know. He's a person that gives assurance. He's a hard worker. It's a long story. He don't just get here. This was a long process. That trying to do the right thing instead of hitting the wall. He got arrested this time. He was on his feet. By him being on his feet and get arrested, he loses his job. So now he starts over. Now he has no, because the main thing is for him, his paying his child support. His father was taking his majority of his whole check because he had 3 children. He loved his children. He had a problem. But when he lost his job, he had nowhere to live. So again, he refereed whatever hustle he could get to get a room, just a roof over his head. And that's what he was supposed to.
All right.
And so, Your Honor, I offer this testimony.
Just one second.
My apologies.
Do you have any questions? All right, thank you so much for letting me know about your son.
Your Honor, I offer this testimony so that the court could maybe reconsider its decision in its sentencing, knowing that Mr. Green is going to be getting the help that his family wants to offer, and that they would love to have him come up there to Texarkana, but they do understand that he needs to be admonished and punished and has to take some responsibility. And they're not trying to obfuscate that, and they're not asking the court to ignore that. They're just asking that if the court would to follow the plea agreement, that they believe that they would be able to be in a position to help Mr. Green once he is done with his sentence and can be back with his family in Texarkana, hopefully to get him back on his feet and assist him in any other way possible, as not just being his family in present, but also being someone that he can rely on and not have to.
Do you have
turn
proof
to.
of his mental health issues?
I do not on me at this time.
All right, so this is what the court is going to do. The court sentence will remain to guilty, revoked, taking consideration 2025 CC 007955, 14 months in the state jail facility, give you credit for any time served in the therapeutic community. If your counsel brings proof to the court of mental health issues, proof to the court from your family of some sort of plan, then the court will reconsider if the state has no objections. And I say if the state has no objections because there truly is no legal motion that's a motion to reconsider. Once the court enters a legal sentence, that legal sentence stands. So the state would have to agree to allow the court to reconsider. Do you understand?
Yes, please.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right, thank you. And when do you anticipate having that information?
I will get it to the state if I can before the end of the week.
All right, then you need to speak with Ms. Ferguson about putting it on the docket for a motion to reconsider.
Yes, Your Honor. Thank you
Thank
very
you.
much.
Your Honor, does the court want an actual motion?
Yes.
I will. Motion. No, it's that.
All right, anyone else?
They're ready on the Mason page
Not yet,
4.
not yet. I still
Oh.
have, I'm talking to Mac.
Oh.
Amazing.
And we have.
And has he even been brought out?
Yes.
All right, thank you. Yes.
Page 6, third one down.
Donna Ellis,
Yes, ma'am.
Yes, Your Honor.
if you'll come forward, please.
Good morning, Judge. How are you today?
Morning, I'm doing okay. How are you doing?
I'm doing good, Judge.
All right, what is happening with this case?
Judge, we have a plea agreement worked out with the state. However, I need to obtain some additional information from my client. She does have it in her cell at the jail, some timesheets and some judgments. So I intend to go there within today or tomorrow.
So if you have an agreement worked out, why can't you do the agreement?
We just need to get those timesheets to present to the court, Judge,
Timesheets for,
for time that she has spent in custody, Your Honor.
oh, they'll be able to look that up.
I don't believe that they saw the reflection when I was speaking to
Oh,
the staff.
Well, I can tell you, if you enter a plea bargain agreement, the court is going to grant you legally, I must grant you any time that you served in custody. And if there is something that you feel as though you're not being given credit for, they do a nut pro tunc to make sure you get your appropriate credit. All right?
Okay.
So if y'all will complete the agreement, please.
All right, Judge. Yeah,
Thank you.
so the court wants to go forward without having
Yes.
the proof today? Okay.
Anyone else ready?
Please come first.
All right, thank you. Anthony Jacob Herrera, I think that's been done.
State, so she's after teeth, so. Okay. No, I know, I appreciate it. I just figured you. From her, because she has the time, she's put it out. I'll be back. I gotta go right back for a second. Thank you.
Oh, counsel,
Yes, sir.
once your client has been brought out, I ask that people not leave the courtroom, because if your client is here, then no other inmate can take their place, because for security reasons, they're only allowed so many inmates in custody
Yes, sir, I
and in
understand.
the box.
I have two clients in 379 though that I have to take care of with the permission from the court. May I appear in the 379?
Sorry. State, if you all can get his paperwork ready for him. Jesse Noel Ramos. I don't see him here. Oh, he is here. All right, let me know when you're ready.
Yeah, that's, we have a little snack. You're trying to work it out.
Okay, all right.
The snack is if the VA was here, is not here.
Okay. Oh,
So he's verifying whether we agree.
okay. All right, awesome.
I think she might be on vacation, so she can get a hold of this to make sure.
All right, thank you.
If he does, then it's a go.
Okay, all right, thank you. Brendan James McCaskill. Maria Magdalena Cisneros. Thank you. Just have a seat. And has Akili Brooks. Thank you. All right, where are the students from St. Mary's? Yay, St. Mary's School of Law, come on up. Hello, come on up. So are you guys first years, second?
Second years.
Ooh, two L's. So how are you guys enjoying it? You know, it's gonna be great, but you all can sit here. Yes, and then let me get a second chair.
Then we got a chair from the bottom.
Yes, so we can have a chair. You all guys can sit here so you can see what's going on. And if you have any questions about anything, I'll explain it to you, all right?
I appreciate it. Thank you.
Sure. Welcome, welcome. And I'm sorry, what's your name?
Good.
I'm sorry?
Gabriel.
Gabriel?
Brianna.
Brianna. Oh, okay, I'll be able to remember that.
Miss Alice, can you move one over? Yes. There's that chair right there, that wooden chair.
Oh, you can just sit here. Yes. And so you guys can sit here. This is usually where witnesses sit.
And then I guess.
Yes.
They're not ready on Mason of the ordinance. Difficult.
All right, Eric Wayne Mason.
Mr. Mason? The box.
Come down, sir. Hi, Mr. Mason. All right, so your attorney is out ill. I don't know when your attorney is going to be available. So it may be best, yes,
Yeah, we're expecting it back within the month,
what, this month? So you have a choice. You can either continue with this attorney, but what I can tell you, if your attorney is still out and unavailable, there's going to have to be a new attorney appointed because these cases have been around for a while. Do you understand? So here's my question. Do you want this case reset? It'll be reset later this month. And that attorney will have to appear, or would you like another attorney appointed to represent you? It's completely up to you.
Would be my friend, so if I want.
I believe the max is somewhere to point to another.
Yes.
If that,
But it would also have to be said.
No, I mean, we'll get you an attorney here today.
Okay.
So what would you prefer?
After today.
All right, just have a seat. We'll make sure you have an attorney today. All right, thank you.
Thank you very much, Your Honor. May we excuse?
Yes. Thank you so much for coming down.
oh, you're welcome.
Oh,
Yeah.
and excuse me, y'all may want to make sure that he's on the misdemeanor cases as well. Because he has I think 2 or 3 misdemeanor cases. Do you need the cause numbers for those?
If you can, thank you.
It is 2025 CC 008188 and 2025 CC 008203.
Okay, I will make sure.
All right, thank you so
Okay,
much.
You're welcome.
So anyway, sometimes you have cases, maybe attorneys are out ill, maybe attorneys don't show. And normally attorneys are not reappointed. But if somebody maybe hasn't spoken to their attorney in a while and they say they haven't spoken to their attorney for a while, or sometimes there are conflicts, then what will end up happening is a new attorney will be appointed to the representative. Because otherwise, cases will be on the docket forever, and we can't have that. And then we have motions to revoke. So motions to revoke, those are, well, let me back up a little bit. Anytime somebody does a plea agreement with the court, that's a contract. And so when somebody is violating that contract, that becomes a motion to revoke. So here on the criminal side, when the contract is violated, it's a motion to revoke for pleas. And so with contracts, like you learn in school with contracts, it's the 4 corners of the document, right? Well, it's sort of the same here. And parties can't agree really what a sentence will be because the contract says what it says. Now, sometimes as a judge, you can go outside the boundaries of the contract if you're going to sentence somebody to less than what they could have received. So sometimes you'll see that happen. Sometimes you'll see parties, hey, judge, we would like for you to give this person a year in the state jail facility or 5 years instead of life. You know, you take that under advisement, but if somebody's placed on deferred adjudication for a first-degree felony, the contract says if they violate that contract, they're looking at life in prison. Now, parties can come before you and say, hey, judge, we think they should be revoked. We've agreed they should be revoked, but we don't want you to sentence them to life, even though the contract says you can. We would prefer 5 years or 6 years, but they're really not allowed to enter into the plea bargaining agreements at that point because the contract is what the contract is. Anyone else ready?
I'm preparing to, please.
All right, thank you.
Email forwarded on page 5.
Okay. Oh, Norma, this has already been taken care of. Yeah. I mean, is this? Oh, this is someone different. Okay. Yes. This is a light docket. Yes. Usually we have about maybe 60 people. And I'm like, why is this docket light today? I don't know. So let me show you. We usually are in jury trials on Tuesdays. Tuesday afternoon, we do jury selection. So, and this docket may change. This is the docket for Tuesday and Thursday. So everybody on that docket is to appear in court. Sometimes you'll see where it says somebody's in federal custody. When people are in federal custody and they have pending cases, they will not send them to state court until that gets completed. Now, on the federal side of late, their cases have been set into the new year. So there's nothing I can do with my case because they won't bench warrant them over. They're not allowed to until that case is finished. They don't allow them to zoom in, so we're just stuck. Yes. Oh, I haven't done anything yet. Yes. No, you haven't missed anything. Oh, let me see. All right, we're gonna see if the obsession should be.
Yeah, I'm gonna buy. With this bigger container like logo.
Okay, I may be obsessed with this too. You know, I like the feeling and the fact that it doesn't feel oily. Oh, it's awesome. And usually I don't like vanilla.
I usually don't either. I'm not liking vanilla candle and stuff.
No.
But this cream.
Oh, I like it.
Which I like the 2-inch.
Oh, thank you. All right.
Not really.
I mean, the docket is short. I think we'll see where we are. All right, Maria Cisneros, come forward. Hello, how are you doing? All right, so anyway, you know, as I told you before, you've had your chance to have everything worked out, so you're not allowed to homeschool.
I brought my daughter with me, just so you could know that.
Sure.
My grandchildren, that, which is her.
Sure. Where's your granddaughter?
My daughter's right there.
Your daughter? Come forward.
Denise.
Hello.
Hi.
Hi. So your mom's attorney could not be here today, so we're not going to do any other modifications to the bond, but she's not allowed to homeschool.
Okay.
And the reason being is because what she's charged with, and I mean, let's be honest, like if she wasn't your mother and if she had these charges, would you allow a person with these charges to homeschool? So, and I understand sometimes finances are a certain way, but based upon what she's charged with, if I continue to allow her to homeschool and something were to end up happening, that's on me. And I know you're probably thinking, well, nothing's going to happen because that's my mom, right? And so I understand, and I understand finances are an issue, but part of my job as a judge is to protect the community. And I protect the community if somebody's on bond by setting specific bond conditions. Now, what I can tell you is her attorney states that he's not going to be able to be here today. He can put it back on the docket if he wants to put it back on the docket because he has jury duty on the federal side. And on the federal side, when you have jury duty, if you don't show up for jury duty, they send the U.S. Marshals to pick you up. So he wouldn't be able to be here anyway. And if he were here, the U.S. Marshals would come pick him up and say, you have jury duty. So for now, I'm not going to allow her to homeschool. All right. So make sure that doesn't happen. And here's the thing. If that ends up happening, and if the police or somebody discovers it, say, for example, something that happens at your home where the police are called out. Could be something simple, like they're investigating something at a house next door and they want to talk to you. They're going to see, because her name is going to come up when she gives them her name. They're going to see that I have conditions in there. And if your children are there, you know what's going to end up happening. They're going to call you and they're going to call Child Protective Services. And then her bond's going to be revoked and she's going to end up in custody. And she's going to come back to here and want to explain to me why she violated my order. You understand?
Yeah.
So you're not allowed to, okay? All right, so what we're going to do is we're going to reset you in November so that you'll have a setting date.
Okay.
And if your attorney wants you brought back sooner, he'll let us know. But I'm giving you the November setting so you'll have a set date where you know we can come in and address this. But he may have you in early. It just depends on what happens with this jury service over there, all right?
Okay.
All right, Ms. Ferguson. What day in November is good for you? Do you want the beginning of November?
The middle part?
Well, I mean, do you want it heard as soon as possible?
It is whenever. Whenever best for you.
No. I'm here all the time.
Oh.
So we can put it that first week in November. All right, I need the beginning of November reset, November 3rd. All right, so we're going to call you back on November 3rd. Make sure that you're on time, okay?
Yes, ma'am.
And thank you for dressing appropriately for court.
Thank you.
Once you sign the reset form, you'll be excused. And thank you for coming in.
Thank you.
Thank you.
Right here.
Thank you.
All right, anyone else ready?
Yeah, just on page 2, second one.
All right, Jesse Lutzenberger. And where's the other attorney? He said he had a plea. Oh, he's going over paperwork. So This is a plea bargain agreement. The court is calling 2025 CR 003-507 State versus Jesse Lutzenberger. Can I have parties announce?
John Whalen for Jesse Lutzenberger.
All right, excuse me, in the box. You all need to lower your voices. And are you Jesse Lutzenberger?
Ma'am,
Counsel, have you received all discovery? Did you review it with your client?
we have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lutzenberger, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yep.
That's either yes or no.
Yes.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Any objections?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
The 2-year.
No. Did you review this document? Did you understand it?
Yeah.
Did you sign it in all the appropriate places?
Yes. No.
The state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Lutzenberger, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization and denied re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. There's a $500 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
That's either yes or no.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours community service restitution, no contact with Mario Montemayor, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
It offers states one.
No objections, Your Honor.
All right, and state, have you had a chance to speak with the complainant?
Yes.
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing state's exhibits and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Just that we wish that you follow the agreement, Your Honor.
All right, what were your issues that day?
Were my issues that day?
Yes.
Well, I couldn't believe it was happening because all I wanted to do was go vote.
No, the problem was not you going to vote. And I will tell you, I teach campaign and election law. And when people at a location tell you that you're not allowed to wear certain items when you go into the voting booth, you're not allowed to do that. When they tell you you're not allowed to wear certain items when you're entering doors, you're not allowed to do that.
They told it, it wasn't posted anywhere, and the people that were working there didn't know themselves.
No,
They
that's the
would have
law.
told me that.
I'm telling you, that's the
Well, I'll
law.
tell you, I didn't know, and other people didn't know.
Well-
Like I'm explaining my situation. That doesn't seem that anybody's heard yet.
Oh, well, let me just tell you what it says in here in the police report, because maybe you didn't read it. It says you were walking in and the person, they have judges who are there for voting and they have people who are working there, who work there. It's yes or no. It's not, They were working there and they told you you needed to remove your hat because it was not allowed inside the voting area. And that's the law. And that's always, but here's the thing. That's the law. It's always been the law. For example, I can't walk around with a t-shirt with my name on it saying vote for me and go in the voting booth. It's not allowed. Once you get to a certain point and it's that 100-yard line that they have, when you cross into that area, you're not allowed to be in line with t-shirts about who you support. You're not allowed to do that.
Yeah.
That's the law.
I
And
understand
then when people tell you that, you can't start hitting somebody. And it says on here that your wife even tried to stop you.
Man, that's all incorrect. Do you want me to explain? Can I explain?
Sure. And if you want a jury trial, I'll give you one.
Well, I'm not talking to you, I just want to explain because it's incorrect what they're saying. I was in line for 45 minutes before I actually got to vote. They asked me to remove my hat then, after I was standing there for 45 minutes. So I removed it, I put it in my lower back. I went through the whole voting situation. When I went out the other side, this person that had already harassed me in 2 other previous times that I went to go vote in a different location was again there. I walked away from him twice, 2 other times, when he was verbally harassing me. Okay, this is the 3rd time. And this 3rd time, I walked away from him again twice. He would not let me walk out of that place without harassing me and getting physical with me.
All right. So
That's what my wife was trying to.
let me tell you what it says in here. And I go by this document. It says that the complainant went on by explaining that as part of his duties, he is supposed to advise voters that they are not permitted to wear or display candidates on their person while they are on the polling premises. It says he observed an older adult male inside the polling premises, and you had displayed campaign material, which was your hat. He observed the violation. He contacted the male and advised him that he would need to refrain from wearing the hat while on the premises. The complainant explained that the male complied with his instructions while he was voting, but then put the hat back on as he was making his way to exit the premises. At the time, the male was still inside the building and clearly well within the premises. Due to still being well within the premises, he approached you again and advised you to remove the hat while he was on the premises. The male, that's you, explained that he was on his way out and refused to comply. And it says, he began to follow you and told you again to remove your hat. And as you were about to exit, you struck him on the chest and facial area several times with your fist, causing him pain and discomfort. And then it says, another witness and your wife began telling you to stop. And then that's when you left. I don't know why when people go to places, how hard it is to follow instructions. When they say you can't do something, you can't do it. And if you want to complain about it, complain to your legislature. If you want to wear campaign materials inside a location while you're voting, if you want to wear it within the 100 lines, because they have those lines marked with a white, sometimes yellow line. If you want to do that, then you need to write your legislator and say, look, you need to change these rules because I want to wear my campaign gear inside the area while I'm voting. But for now, you're not allowed to do that. And you need to follow the rules. How old are you?
Or
All right, you're 64 and you're up here fighting at and I don't even call it fighting because it doesn't say that he ever even hit you back.
yeah, of course.
And so you're up here fighting with somebody who's just trying to do their job, help people come in and vote and go on your merry way. And they're not even paid enough money for somebody to be hitting on them. So it appears to me you do have anger issues.
No, I don't have any. Like I said, I walked away twice, and in the situation, I walked away twice. To say anything in there where he followed me all the way and he screamed in my ear. I have hearing difficulties from my time in the military. I didn't hear what he was saying. I was walking out, and he was quite a ways.
Did he not tell you to remove your campaign gear
No,
and that you were not allowed
That was-
in the area?
that was after the fact when I had already gone out. I was in the library section already.
Let me just tell you, within that 100 line, you are not allowed to wear campaign gear. Now, if you're saying what's being said is untrue, then you need to set this for a jury trial because I go specifically by what's in the police reports. And there's a reason why this says waiver consent to stipulation of testimony and stipulations. You know what that means? That means that everything is in this document. You're stipulating that it is true and correct. And this is what it says. I, Jesse Luxemberger, do hereby judicially confess and admit that I intentionally and knowingly in Bexar County, Texas, on or about the 24th of October, 2024, did intentionally and knowing cause injury to the complainant by striking the complainant with the hand of the defendant and by pushing the complainant with the hand of the defendant. That's, you stipulated to that and said it's true.
Say anything about him punching at me first.
What I'm telling you is you're saying this is true. You've stipulated to this. Now, if you're saying he punched you first, then maybe you want a jury trial and you want to say it's self-defense.
It's on video. The only reason why I'm accepting that because I don't have the money to continue. Or of course I would defend myself.
All right, does he
That's
want a
fine,
jury
we'll keep
trial?
going. No, we're accepting the plea. Or, you know,
Is your wife, is somebody here?
My wife is here.
Oh, she said, no, you don't want a jury trial.
Okay, no.
All right.
Your Honor, if I may, I believe that, look, point being there's, as you stated, that's completely clear. The law is the law. I think that there was a fundamental miscommunication and understanding as far as how it was proffered to him at that time. I think that realistically, the way people speak, someone told him, take off the hat while you're voting. I think in his head, that's what he believed. Hey, take the hat off. I'm walking out the door. I'm basically at the double doors. I can put the hat back on. Understanding clearly that is still in violation of the law. But I want to make clear, it's not like the statute book was not pulled out and read to him at this time to understand the 100 feet. Again, it's not an excuse, but I think where his mind was coming at, he had finished voting, he had waited the 45 minutes and he was leaving. And then he had an individual come up and approach him. Just to give some context, it's not change, obviously, the law itself or your viewpoint of this, but I want to.
Well, I mean, my viewpoint is the stipulations that I received.
Understood.
All right. There's going to be a $500 fine. 2 years deferred adjudication. 200 hours of community service restitution. Proof of employment within 30 days, no employment as a home health care provider or with minors. There's going to be the hostility management course, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months. And there's to be no contact with Mario Montemayor. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, I'd just like to say that all this is my self-defense. Because nobody wants to be harassed or bullied in front of their significant other.
Yeah. I understand, you know what, I understand here's the thing, I understand what you're saying, and I understand sometimes that tempers run high, right? And sometimes when we don't know the law, and if somebody just tells you, you can't do that, sometimes people want to know why I can't do that, and they want you to explain it. Sometimes people will explain it, sometimes they will not. For example, I try to explain everything so people will know why things are happening. So now you know, and I'm telling you, yeah. So here's the thing, this is what I'm telling you. When you see, if you go vote again, when you see that line, you are not to cross that line with any campaign materials. And that's why when you see candidates who are out there talking to people, they're not allowed to go past that line. You know why? Because you are not allowed to campaign past that line. And wearing T-shirts or any type of hats or anything for whatever candidate you support, whether you say anything or not, that's considered campaigning. And legally, you're not allowed to do that. And if people want to change the law where they can wear their campaign shirts or whatever beyond that line, you have to do that with your legislator. My job is just to follow the law. You understand?
Mhm. Yes, ma'am. This happened in Georgia and it happened in South Carolina, I think, and the people still got to go and went on their way.
Well, this
Different place, right?
is Texas.
Yep.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is plea bargain agreement, because I've followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Ms. Abrams will speak to you.
Okay.
All right. Thank you.
Thank you, Your Honor.
You're welcome.
Right.
All right. Who is ready?
You want to do some resets?
Whoever's ready. Well,
Or do you want to come
are you ready for the plea?
Yes.
Let's do that,
Okay,
because
page
that
3.
attorney needs to go to the court.
Page 3, report down for Christy Rhodes.
All right, let's see. Christy Riojas. Come up, Christy Riojas. Court is calling 2025 CR 008178 State versus Christy Emilio Riojas. Can I have parties announced?
Robert Brabant for Riojas.
And are you Miss Riojas?
Yes, ma'am.
I'm so sorry about mispronouncing your name. You can lower your hand. Counsel, have you received all discovery?
Yes, ma'am.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No application, Judge.
Ms. Riojas, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter a plea in this case? Counsel, has your client have been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, she's mentally competent. Yeah.
Ms. Riojas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney, and did you understand it? According to the plea, punishment is to be assessed at 96 days in the Bexar County Jail under 1244, and there's a $1,000 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
Yes, ma'am, it is.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Stenographer states one in attachment.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State, you may be excused. Thank you. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
No, just to follow the plea agreement.
All right, the court will follow your agreement, sentence you to a $1,000 fine. Time and money will run concurrently. The court will sentence you to 96 days in the Bexar County Jail under 1244 and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Obviously, you have a drug problem, right? When you're released from custody, if you cannot find a sober living place, or you need some help finding a place to go, if I'm still here, you come back here, I will pick up the phone and call somebody to help you. You understand? Because if you continue like you are, only one or two things going to happen. Either you're going to be in and out of jail, in and out of prison, or somebody may end up having to identify your body, because the last time you use may be the last time you use. You understand? All right, good luck to you. Thank you,
Thank you,
counsel.
Judge.
Who's next?
Good night.
Ekala Brooks. Hello.
Hi.
So yes, we have issues.
Yes, I have been talking to probation. I was his last NGR attorney, so I didn't know I would be his attorney today.
Okay.
I've been able to talk to him a little bit.
Mhm.
I have other courts that are kind of saying, where are you?
That's fair.
I've talked to probation. We need a little bit more time. I understand what the recommendation is.
Mhm.
I've discussed that recommendation with the client. But I'd like to get, I know he would like to move to Idaho, and that's where he had started.
Well, I can tell you what's gonna happen today is a motion to revoke is gonna be filed. So you'll need to take a seat in the box, sir. And then you can set it whenever you wish to set it.
Will the court consider daily reporting to
No.
probation until we just have a reset, recall it this week?
No, we can still recall it this week, but they're gonna file a motion to revoke.
Okay.
All right. All right, are you all ready?
Page 2, 5 down on your way.
All right, where's his plea?
Judge, it's paper ready. However, I understand that there's 5 or 6
Are they-
other attorneys waiting in front of me.
No, just swear them in.
She still needs to swear him to.
Okay. So who is your,
John Lopez.
all right, Lopez.
Thank you.
Hello.
Judge,
How's it going? How's the eye?
surgery tomorrow.
Oh, it's gonna go well.
I think so. I think so.
I always find it strange when you see eye surgery and people are still awake and it seems like the eyeball wants to move.
It's kind of a clockwork orange type of feel to it. You're mostly asleep and a little bit awake. So.
Ah. So on this case,
We have been in negotiations and discussions with Mr. Spears. And regarding his, we need to review a forensic interview of this child. We have already scheduled one for this coming Wednesday afternoon. And would like to have this matter reset, given Mr. Spears' health concerns.
oh, all he has to do is put his offer in the file and somebody else can come down, right?
No, yes, Judge, I'll have somebody come down where they can, we'll arrange it to somebody.
I didn't finish what I was trying to say, George. I did not finish what I was trying to say.
Okay.
We were asking that the court recall this matter for October 15th, which is next week, not this coming Wednesday, but next coming Wednesday.
Yeah, I'll recall it for October 13th.
I
It's
think
fine
I
with me.
will likely be back, Judge. My doctor said I'll be out the rest of this week. It's
Okay.
possible it could be go into next week. If there is a complication, I'll contact Norma.
All right. All right, we'll see you back October 13th. And that's your final day for plea deadline date. All right, thank you. All right.
I don't think there'll be, but I'll let you know.
Donna Ellis.
Lopez.
Court is calling 2023 CR 3770 State versus Donna Lynn Ellis. Can I have parties announced?
Flores knows for the state.
Peter Calderola standing in for Gail Calderola for Miss Ellis, Your Honor.
All right, do you have any objection to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ellis, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention with a vehicle. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison. and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do so believe, Judge.
Do you believe she is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I believe she was.
Ms. Ellis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an $800 fine. There are no applications. The state will take in consideration CC 701359. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None that I'm aware of, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. What is happening with the drug?
I believe which case, Judge?
Well, in the police report, they say that she had drugs.
That was rejected, Your Honor, back on 5/2 of 2023 when our office received notice.
Right. All right, is there anything else you wish to say on behalf of your client?
Yes, Judge. I understand that my client, I believe, has 128 days credit here in Bear County. However, she's been in custody since the inception of this case. She was sentenced to TDC out of a different county. And that sentence occurred, I believe, in December of 2023. So my client has roughly about 1 year and 10 months of time at TDC. So we're asking the court, respectfully requesting the court satisfy this judgment today.
All right, then she'll receive, well, I'm not going to judgment satisfied, but what I will tell you is you'll receive custody for any time that you've been in custody while this case has been pending. All right, so if you were in custody and this case was still pending, I'll give you credit for that.
Okay.
All right. So do you know which TDC case number that is?
I do not have the TDC case number. My client does have that information in her jail cell.
So what we can do is just, your counsel will call the court and he'll let us know which case number it is, and I'll have it run concurrently with that, and you'll receive credit for that.
Yes, ma'am.
All right.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, normally, Miss Ellis, I will recommend the therapeutic community for people who want it. but it appeared in the police report that you said you did not want to stop using. So do you want me to recommend the therapeutic community for you? It doesn't increase the time that you're in custody, but it's to help you with any other issues you may be experiencing.
While I was in TDC, I completed a 120-day MTC program, drug rehabilitation
Okay,
program.
that is awesome.
Also anger management, and I got extra college credits. I was also a teaching assistant for GED to my other peers.
Mhm.
I completed a Christian 12-step program. So I wasn't just sitting there idly by.
All right, so has that been helping you?
It has.
All right, so this is what I'm going to tell you, what I've noticed, and I don't want you to fall into this trap. Usually when people get out of prison, they celebrate and it goes downhill from there. So when you're released from prison, if you cannot find a sober living house or someplace to help you, if I'm still here, you come back here, I'll pick up the phone and call somebody to help you.
Yes, ma'am. I
All
do
right.
have a place to go.
Oh, that is so awesome. All right, well, good luck to you.
Thank you very much.
All right, thank you.
Thank you, Your Honor. May we be excused?
Yes.
And I will be in touch with the court to provide that TDCJ number.
All right, thank you. Oh, yes, we are going to stop at noon.
Either today or also at the jail this for tomorrow, okay?
Thank you.
Counsel, did you get your dismissal from the state to take to the other court?
I do have a judge.
All right, thank you. Anyone else ready?
Yes, page 42 down.
All right, Eric Mason. All right, Mr. Mason, come on down. All right, so discovery needed.
Yes,
All right, how much time are you asking for?
30 days so I can get all the discovery and go over it and then go over it with my client.
All right, Ms. Ferguson, I need a 30-day reset for discovery and state at that time you'll need to be prepared to tender an offer.
November 5th.
All right, so we're gonna,
Sorry, November 4th, Judge.
all right, so we're gonna be back on November 4th. If your attorney wants to come back sooner, he can let us know and we'll put you on the docket sooner, all right?
Okay.
All right, thank you. Thank you for your patience, okay? All right, thank you. Have a good one.
Tomorrow, Mr. President.
Here.
Thanks for the appointment, Judge.
Oh, no, thank you for helping. All right, who's next?
Page 5 going down. Hold on.
Julian Tovar.
That's also mine, Judge. I've conferred with the state. I believe there's still some discovery that's outstanding.
Yes, Senator, we did have some Instagram messages, which I did just receive, and in the process of uploading. That's gonna be good as well.
All right, Ms. Ferguson,
Yes, ma'am.
recall this on the same date as his previous client. We'll call it for November 4th and state at that time you need to be prepared to tender an offer.
Yes, Your Honor.
All right, thank you. Anything else?
Nothing.
All right, thank you.
Thank you, Judge.
Welcome.
You got page 8 down.
All right, so this is a motion to revoke. That they violated the contract. That's what the state is alleging, because they're on probation, and they're on probation for aggravated robbery. The range of punishment is 5 to 99 years or life in prison. So either they're gonna do a contested, when they do a contested, what that means is that the defendant is saying, this is not true, what's in this motion, so I want to fight the charges against me. And then what they'll do is the state will have to call witnesses, but on motions to revoke, the burden of proof is less. You know how normally in law school, they tell you it's proof beyond a reasonable doubt? But the allegations in this motion is preponderance of evidence. All right, who's here on Jacob? I'm sorry, Joshua Jacob Cannon? Yes. Hello.
Good morning, Your Honor.
Morning.
Jason, your hand's working on.
Okay. Hello.
You put him on the left or the right, Judge?
Oh, no, he's in the center. You're on this side. All right, so are you all proceeding on the motion to revoke?
We had the recommendation that MRT, this is gonna go forward. Yeah, that's the MRT and the ILB.
All right, the court is calling 2023 CR 2570B State versus Joshua Jacob Cannon. Can I have parties announced for the record?
Jason, Your Honor.
Mark lift for fence, Judge.
And are you Joshua Jacob Cannon?
Sure.
All right, so here's the thing. You got to save the tears because we're here on a motion to revoke because the state is alleging that there are some actions that you did that were a violation of your conditions. Do you understand? All right. So are you the same Joshua Jacob Cannon who was placed on deferred adjudication in 2023 CR 2570B for the offense of aggravated robbery on June 12, 2023 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, and we're proceeding with number two, that is the second to last number two.
Okay.
There's a violation of condition number two on or about the 16th day of August 2024. The Bear County says that Joshua Jacob Cannon and then in there commit to the illegal use of controlled substance, mainly marijuana, violation of condition number two.
How do you plead to that, true or not true?
True.
Waiver may violate.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number two, the court could find it true, grant the motion, find you guilty, and sentence you to life in prison?
Yes, sir.
Do you understand if you have some sort of an agreement that you've worked out with the state, I don't have to follow that. Once you've pled true, I can sentence you to life in prison. Do you understand that?
I understand.
Knowing that, you still wish to plead true to violation of condition number two?
Yes.
Court is finding violation of condition number two true. Is there a proposed agreement?
There is, Your Honor, it is denied a motion to adjudicate, continue the individual on the deferred. With the amendments to add MRT first and intensive outpatient treatment.
All right, is that the proposed agreement?
It is, Your Honor.
All right, let me ask you something. Do you want to go to prison?
No, ma'am.
Then why are you doing this?
I make bad decisions.
No, I mean, here's the thing. You have decisions that you have to make. And on the one hand, your decision is, do I want to do this? If I do this and I'm caught, I can look at life in prison. And then what ends up happening is your attorney has, and this is where I've been a defense attorney before. This is where the attorneys are throwing themselves on the mercy of the court saying, please let this judge follow our agreement, even though I don't have to do it. So when you're making decisions and knowing you could go to prison and you're still choosing to do this nonsense.
I've been going to NA meetings. I've been going there for 2 weeks. So I've been trying to.
Well, but see, here's the thing. You've been on probation since 2023 and you only have two weeks. What have you been doing with your life? Do you have employment?
Yes,
What do you do?
I work for Hill Country Waste Solutions. I've worked 60 hours every week.
But you find time to do this. So, I mean, I will tell you, and your attorney will tell you, and Mr. Garhan will tell you. How old are you?
20.
You're 20. Do you know how many 20-year-olds are at the prison? A lot. And if you don't want to get your life in order, you know what's going to end up happening? You're going to be at the prison. I will still remember you because I remember all the people who come through here. But you know what everybody's gonna say? Oh, well. And this is what I can tell you about the government. The government may not have money to build state hospitals, but they will always find money for the prisons. And whether or not there's supposed to be 5 people in the cell or 2 people in the cell, they will put 5 people in that cell. They will put 6 people in that cell because they're not going to let you just be out here and say, oh, well, you know, it's overcrowded. So we don't have another jail. So we'll just let him be out here. That's not the way it works. And he can tell you that's not the way it works. And if you're drug tested today, are you going to be positive? You need to tell the truth and shame the devil. What are you going to be positive for?
Marijuana.
Yeah.
So here's the thing. I know people say marijuana is not a big thing, but when you're on probation, guess what? And your attorney will tell you this. You're not even allowed to drink alcohol in your house.
Yes, ma'am.
So you're not even allowed to smoke marijuana in your house. If you do, you know what that's telling me? You want to go to prison. So I'm going to give you a decision. And what I can tell you is, you know yourself better than your attorney does, better than I do, better than probation, better than the state does. So I want you to look deep inside yourself and discover and realize whether or not you can complete this probation or not, because you signed up for probation to be on probation for 10 years. So that's 2033. If you cannot complete this probation and you know you cannot complete this probation, just let us know. I will sentence you to 5 years in the prison. Otherwise, I will follow this agreement that you've reached. They're going to give you UAs and they're going to test for levels. If those levels go up, that signifies that you're using, and a motion to revoke is going to be filed, and we're going to be right back here. So those are your only 2 choices. I'll give you the MRT, the intensive outpatient treatment. I'm going to make you do NA meetings, and they're going to test for levels, or you can call it a day and I'll send you to 5 years in the prison. Which do you prefer?
TR meetings.
Right. Have you had a time to internalize that?
Yes, ma'am.
All right, because I will tell you, the state will tell you, I've sent 20-year-olds to prison before.
And Judge, I know he's very emotional right now, but when I've talked with him, he has conveyed he needs help. I mean, he has been self-medicating. He got in a real bad accident about 1.5 years ago, jacked up his hip, no excuse, but he needs help to figure out not doing that. I mean, he takes full responsibility, Judge.
All right, probation, I'll deny the and I'm sorry, probation, are you recommending this as well?
Yes, Judge.
All right, the court will deny the motion, alternate amending conditions to include the MRT, IOP, and I'm going to want UAs, test him for levels. And he's going to do sober support meetings. In 30 days. And your levels should start going down. Do you understand? Is there anything else you need from the court to be successful?
Judge Austin, do you want me to put that as way?
How often are you, because it's marijuana in his system?
Every 2 weeks, Judge.
All right, so there's going to be UA every 2 weeks until he presents with a negative UA. Is there anything else you need from the court to be successful? All right, we can go off the record. Here's the thing. Everything that you do from here on out, I'm gonna help you with your decision making. If your actions could result in you being revoked and going to prison, you shouldn't do it. If your actions are like, maybe this is something I can get revoked for, maybe not, you shouldn't do it. Do you understand? Because otherwise you're gonna be at the prison. And either you are, well, first a motion to revoke will be filed. Either you're going to make bond or you're not. If you don't make bond, we'll bring you over dressed in orange. We'll hear it. And either you're going to get revoked or not. And either you'll end up in prison or not. Do you understand?
Yes, sir.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome. Oh, well, I have two students here.
Right.
Okay. And here's for your client some tissue.
Thank you, Judge. Thank you, Mark.
So he's an attorney.
Thank you, Judge.
Here's that.
Losing my mind.
Oh, it is new. Just give me 1 second. All right, what are the case?
We have an agreement, but last setting, Judge, and I've talked with the state probation. We had looked into drug court because we believe that, and I don't want to speak for probation, but we believe that he'd be an excellent candidate. We had filed a request he had gotten denied before, but it was because he had an active warrant, so they wouldn't even screen him. The next screening is tomorrow morning, and so the state's not opposed if you would consider resetting him a week, if you would consider allowing him to apply to see if he's eligible for drug court. On Mr. Renteria, and then we have a sentencing on Mr. Gomez.
Okay, just 1 second.
Yes, Your Honor. Are they in your class or are they just from high school?
Oh, they're at St. Mary's, so they're coming by to figure out if they've made the right choice for this profession. I think they have.
Go to medicine. No one likes lawyers.
All right, Ruben Renteria.
Yeah.
So they have this as a contested. Is he gonna enter a plea of truth?
We have an agreement, Judge. Yes, Judge.
All right, so let's have him enter his plea of truth. The court is calling 2024 CR 2438 State versus Ruben Renteria. Can I have parties announced for the record?
Chief, you're here for the state, Your Honor. Mark Wood for defense.
And are you Ruben Renteria?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and State's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
I did, Your Honor.
Are you the same Ruben Renteria who's placed on deferred adjudication in 2024 CR 2438 for the offense of just 1 moment. Possession of a controlled substance, penalty group 2, 4 to 400 grams on September 26, 2024 for a period of 8 years. Is that you?
Yes, ma'am.
All right, state.
Violating condition number 1, under ballot for 6 days of April 2005, third county, Texas, the defendant Ruben Renteria made the offense of evading arrest about it.
How do you plead to that? True or not true?
True.
And state, do you waive the remaining violations? Oh, is that the only one?
That's all.
All right. All right, I have. Ah, okay, I see. Oh, that's the only violation. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
We are looking. I mean.
Sorry, Butch. It's
Jason's filling in on
Yes.
another prosecutor, Judge.
It looks like, I believe that it's a little bit different. Initially, we were agreeing to deny the motion in an adjudication deal. We were gonna continue the individual on deferred with, status orders. But I believe that, since for this scope with, the probation department, and I believe that he is a candidate for drug court, so he's supposed to be evaluated for that.
All right, off the record from. So until those are taken care of, felony drug court is not going to accept him.
Okay.
So what is happening with those other cases? You all may want to step back and confer.
Yeah, Judge, if you don't mind.
Sure.
Thank you, Judge.
All right, so what we'll do is we're gonna have to bring him back at 1:30 because it's
Yes, Judge.
lunchtime.
Yes, Judge.
Okay, all right, thank you. So we'll bring you back at 1:30.
Thank you, Judge.
You're welcome. All right,
It's Darwin Gomez, but that's his, PSI judge.
all right, so we're gonna come back at 1:30 for that.
More than are asking for recess. One of them is,
All right, let me see that.
it's, Adrian Holmes, H2, one down.
Adrian Holmes. Are you on Mr. Holmes?
I am not.
No, I mean, are you on Adrian Holmes?
I am.
All right, my understanding is he's currently incompetent.
Correct.
All right, Ms. Ferguson, if you can set this in February, please. And counsel, if he regains competency before then, let us know.
They're trying jail-based, so we'll see.
Yeah.
Okay. If they're trying jail-based, then Norma, bring it back. Let's do December.
I can do, can we do the last week, Judge?
Yes.
The 18th, December 18th.
Okay.
Good, thank you.
All right, thank you. So whenever you have somebody is incompetent, that means that they don't have an understanding of the proceedings against them. And once that's declared, there's nothing that you can do. You can't proceed on anything else until they regain competency. All right, who else for a reset?
It is Naomi Alba, H4, one down.
Naomi Alba?
He didn't make the cut.
All right, so 1:30, has she already been sent back?
Your rules, Judge.
All right, so she's back? She's been sent back?
She's downstairs. You still want her, Judge?
1:30.
You're breaking the rules now.
I know, I hear you, 1:30. You need to be back here at 1:30, counsel. Carlos Martinez, who do you have? Mhm.
And the family has not come back, and they went to, they brought cash.
All right, so I tell you what, if you want to, you can appear by Zoom. Because we're gonna take our lunch break. All right.
Give them the lunch break.